50 years of emergency, as we all know, the nation has traversed different journeys through that. And to understand the 50 years of emergency and its impact, we had requested Mr. Raghvendra Seetharam, Srivatsa, a senior advocate in Supreme Court of India, to share his knowledge and insights. And he accepted to share his knowledge. And we are also glad that Mr. Prashant Chandra, an advocate from Bangalore, has also joined us, and he has also done a session with us. And I would request Mr. Raghvendra to take over the baton and show us the insights regarding the same. Over to you.
Namaskar. Good evening to all of you. Firstly, I profusely thank Mr. Vikas Chaturth of Beyond Law CLC and Trivikram Associates for giving me this opportunity. You know, as Mr. Chaturth mentioned, 50 years of emergency is actually a watershed moment, not in a positive sense, because we know, and I must say this, I will be beginning my talk with a cliche if I say that the days of emergency were dark days. But we have no option. But we must always bear in mind the warning that Nani Palkhiwala has given us, that nations which do not remember their past are condemned to repeat it. So when Vikasji and I were discussing the topic for today's discussion, we zeroed in on the title as 50 years of emergency. I must also tell you that last week I had authored an article in Kannada, which is my mother tongue, and a leading Kannada daily had published a center page article on 50 years of emergency. So I have been getting feedback from various sources, friends, well-wishers, seniors, guides. So a very eminent senior advocate practicing in Supreme Court, a very dear friend, called me and said, I'm very happy that you're speaking about 50 years of the emergency, but he said, you know, the title should actually have read 50 years to emergency, because he said 50 years of emergency could convey a meaning that we are in a continued sense of emergency. Nonetheless, now today we are here as a group of lawyers debating on what the country, the constitution, the legal system, and the citizenry had to go through during the days of emergency. Now, today's discussion will focus only on the legal and constitutional issues that arose during the period of emergency between 1975 and 77. I will also clarify that situation because in 1975, in June 1975, when the internal emergency was imposed, there was already an emergency operating. I'll come to that a little later. Now, in this period of 25th June 1975 to 21st March 1977, there were a large number of constitutional amendments, amendments to various laws, and those amendments were given retrospective effect. The laws were put in the 9th schedule. There were issues regarding separation of powers, independence of the judiciary, civil liberties. So various issues arose, and lawyers and judges played their parts, some very well and some not so happily. So as lawyers and responsible citizens of this country, we have a duty to be on the guard and watch out for any infraction of civil liberties. So having said that, I will confess that I will steer clear of any political aspect of the emergency or any political comment. If there is any incidental reference to any political situation, that will only be if such a situation is well documented. Now, the 1970s had been a very eventful decade for India. In 1971, the Indo-Pak War broke out. And 3rd of December 1971, there was a presidential proclamation of emergency. And that emergency under Article 352 was because of external aggression. Now, the proclamation of 1971, because of external aggression, continued till 21st March 1977, when the second emergency was also revoked. Now, references to emergency in today's discussion will only be to the emergency, internal emergency imposed on 25th June 1975, which continued till 21st March 1977. Now, there is a little background to why this internal emergency came about. Now, there was large-scale resentment in the country. The opposition parties were exerting pressure on the government, condemning the various policies. The economy was doing badly. There was large-scale unemployment, and so various issues had come up, and the government of the day had its own advisors. Now, my research has shown me that as early as on 8th of January 1975, please note the date, 8th January 1975, more than 6 months, more than 5 months before the actual proclamation of emergency was issued. 8th January 1975, Siddharth Shankar Ray, the then Chief Minister of West Bengal and an eminent lawyer, and who was also the advisor to Mrs. Indira Gandhi on various legal aspects, sent a handwritten note, and this is documented, a copy of that is available. Handwritten note to Indira Gandhi saying, "Dear Indira, we have met, the law minister, the president of the Congress, and all of them had met, and they wanted to impose emergency in January of 1975. Somehow that didn't happen, but the immediate catalyst for the hurried imposition of internal emergency in the late night of 25th January to June 1975 was the judgment of the Allahabad High Court, whereby the election of Indira Gandhi was declared void. And the immediate effect would have been that she had to vacate her seat in the Lok Sabha and also resign as Prime Minister. Now, a little background of that election petition, which was filed by Raj Narayan in Allahabad High Court. Raj Narayan was the defeated candidate from the opposition parties from the Rai Bareli constituency. So the election petition was filed in 1971. And in the course of proceedings, after exchange of pleadings, the High Court, which was the election trial court, framed issues, and the election petitioner Raj Narayan wanted an amendment of the election petition. Now that amendment was rejected by the High Court and the matter reached the Supreme Court. Please bear this in mind, in 1972, as early as in 1972, when the matter reached the Supreme Court at that interlocutory stage on amendment and the framing of issues, the matter was decided by Justice K.S. Hegde in 1972, that is 1 year before he was superseded. Now, Justice Hegde held in favor of Raj Narayan and allowed the amendment. The additional issues were allowed to be framed, and the matter was remitted to the trial court. Now, please bear this in mind, because it was 26th April 1973 that Justices Grover, Shellett, and Hegde were superseded by the then government because of their judgments in Keshananda Bharati. Now, the matter went back to the High Court, and during the pendency of the election petition before the High Court, there was a judgment by Justice Matthew in Supreme Court in what is called the Chawla's case on the aspect of election expenses. One of the issues involved in Indira Gandhi's case was that she had exceeded the limit of expenses permitted under the law. Now, in Chawla's case, Justice Matthew had laid down that if expenses are incurred by supporters or partymen or the party with the consent or acquiescence of the candidate, then such expenses shall also be added to the expenses shown by the candidate. Now, Raj Narayan's counsel was very happy because that would come to their aid. Now, that happiness was short-lived, because here is where the amendments and retrospective amendments started playing around. When the petition was pending before the Allahabad High Court, an ordinance was brought to get over the judgment of the Supreme Court in Chawla's case, and the basis of the judgment was removed, and it was declared that no such expenses incurred by any other supporter would be added to that of the candidate. Nonetheless, that was the first instance of an amendment to the law with retrospective effect. Then, in the course of arguments, when the election petition was finally heard, Shanti Bhushan made a comment. He said, Shanti Bhushan, who was the counsel for Raj Narayan, made a comment that the rules of the game were changed after the game was over. And he made it very clear. He said, it is like a cricket match where you have one of the teams making the rules, and the team that makes the rules will say that if their players have been bowled out, then the rule will say that players who have been bowled out are not declared out, but only those batsmen who have been caught are declared out. So that was the kind of unfairness that this retrospective amendment of laws to suit a particular case brought about. Now, ultimately, the judgment by Justice Jagmohan Lal Sinha was pronounced on 12th of June. Now, 12th of June is a momentous day because many things happened on the political front, which I'm not referring to, but that seems to be the immediate catalyst for the imposition of emergency, because what happened was, on two counts, Justice Jagmohan Lal Sinha held Indira Gandhi guilty of corrupt practices, and some other grounds raised by the election petitioner were rejected. But nonetheless, having found that the two charges of corrupt practices were proved, Indira Gandhi's election from Rai Bareli was declared void. Now, it is recorded that Shanti Bhushan, counsel for the election petitioner, was not in Allahabad High Court that day. He was in Bombay. Now, look at the irony of the situation. He got news that he had succeeded in the election petition, but as luck would have it, in his absence, counsel for Srimati Gandhi mentioned the matter with an application to the judge in the afternoon and asked for stay of the judgment of the High Court. And as things would have it, the Honorable Judge thought it fit to grant a stay for 20 days. So the operation of the judgment was stayed for 20 days, within which time she had to approach the Supreme Court. And the Supreme Court was closed for summer vacation, like how it is today. Ultimately, the matter reached Supreme Court, and Justice Krishna Iyer was the vacation judge who was to hear the matter. Now, Nani Palkhiwala appeared for Indira Gandhi, and Shanti Bhushan appeared for Raj Narayan. Justice Krishna Iyer refused an unconditional stay. He granted a conditional stay, the essence of which was that Indira Gandhi could continue as a member of Lok Sabha. She could sit in the Lok Sabha, but she could not exercise her vote or speak in the parliament. Merely because of her membership of Lok Sabha, she could continue as the Prime Minister. Now, this became a very difficult situation for Indira Gandhi. And in this situation, the opposition mounted its attack, demanding the resignation of the Prime Minister. Now, this happened on 24th of June. 25th of June, in the evening, there was a huge rally organized by the opposition parties in Ramlila grounds in Delhi. It was addressed by Jayaprakash Narayan, Atal Bihari Vajpayee, and other leaders. Now, Jayaprakash Narayan made a demand that Indira Gandhi had no authority to continue as Prime Minister, and huge support was coming about. And he also made a significant statement. He said, Chief Justice A.N. Ray of the Supreme Court, he had been appointed as Chief Justice of India by superseding Justices Grover, Shelat, and Hegde. So, because the government of that day had chosen him by superseding three other senior judges, he made a request that it was in the interest of justice, he should not hear Indira Gandhi's appeal. Nonetheless, that was not heeded, and things happened the way they had to. Now, 24th of June, the interim order was passed, conditional order of stay, and 25th, this happened. Now, before I come to the crux of when the emergency was imposed, something interesting that is recorded by Nani Palkhiwala in his book, We the Nation, I have to share that with you. He says in a chapter where he titles it as Are We Masters of Our Fate? He says there are certain unforeseen forces or unseen hands that are at work, and that actually determine preordained things. What happened was on 24th, when the conditional stay was granted by Justice Krishna Iyer, Palkhiwala writes that he met Indira Gandhi, told her that it was a good order, and he boarded a plane to go back to Bombay. Next to him was seated a gentleman from Bangalore, and he said he was an inmate of a Gandhi ashram in Bangalore. And he said he has some very serious information to share with Palkhiwala. So Palkhiwala was curious. He said, "What is it?" He said, "See, I know a very popular clairvoyant and an astrologer. So it seems he has some predictions to make." He said, Indira Gandhi is going to be the most powerful woman on earth. So Palkhiwala took it in his stride. He said, can she get any more powerful than she is today? But this gentleman said, no, I'm telling you something. In June 1975, Indira Gandhi is going to acquire extraordinary powers. But those extraordinary powers will come to an end in March 1977. Please mark the dates. And this conversation happens in the evening of 24th of June, 1975. He says in March 1977 that extraordinary power will come to an end. So Palkhiwala has recorded this, and later on, much later, after the emergency came to an end, he put this to Indira Gandhi. Nonetheless, now coming back to 25th of June, when the rally at Ramlila Maidan happened and there was large-scale resentment and all that, in the late hours of the evening, the Prime Minister went to the President with a proclamation, and the President simply signed the proclamation of internal emergency, and the emergency was in operation. Now, this happened. Nobody knew about it. Documentation says that even senior officers of the government and ministers were not taken into confidence. But I must say that Article 352, as it stood on that day, did not require consultation or approval of the cabinet. That came in only by a later amendment in 44th Amendment. So this happened, and on the 25th evening, electricity to newspaper offices was cut off, and there was no publication at all. On 26th morning, people of the country did not get their newspapers. The only way people of the country learned about the imposition of emergency was when Indira Gandhi, as the Prime Minister, addressed the country in the morning of 26th of June. Now, on coming to know of this, Nani Palkhiwala held a press conference. He returned the brief, and thereafter he did not represent Indira Gandhi any further. Now, the presidential order suspending the fundamental rights under Article 359, that was issued on 27th of June. Large number of opposition leaders. Now, why opposition leaders? Even some congressmen who were dissenting, like Chandrasekhar, they were arrested. Now, MISA was unleashed on the citizenry. And of course, it is alleged in the later days that large-scale atrocities were committed by the police and authorities. There was a Shah Commission to go into it later on. Those are political matters, but I will refer to the Shah Commission on two aspects which concern our discussion as lawyers. I will come to that at the appropriate stage. Now, on the 22nd of July, the Parliament ratified the proclamation of emergency as is required in law. In 1975, August of 1975, the Parliament passed the 38th Amendment to the Constitution. Now, this is where the series of constitutional amendments come in. Like I mentioned, there are amendments to laws, ordinary laws, amendments to the Constitution. Some of them are placed in ninth schedule, some of them are given retrospective effect. So this is the kind of complex situation that was prevalent in those days. Now, 38th Amendment made an amendment to Article 352, which said that any proclamation of emergency by the President is not justiciable, and the Supreme Court will not have jurisdiction to consider the validity of such a proclamation. Now, this amendment to the Constitution went through like a breeze in the Parliament because most of the opposition MPs were in jail. And there was virtually no opposition at all. Now, Indira Gandhi's election appeal and Rajanarayan's cross appeal were to be heard by the Supreme Court. Now, even as the appeal and the cross appeal were pending in the Supreme Court, another set of amendments came about. Now, the first lot of amendment related to election laws. The Representation of People's Act was amended, the election laws were amended. Now, look at the nature of amendments. The amendment to the Representation of People's Act, they were such that the two corrupt practices of which Indira Gandhi was held guilty and her election was declared void, those corrupt practices did not exist anymore. So therefore, the charges against her were actually null and void. And the second amendment was that any election held to the post of Prime Minister, that was a constitutional amendment. Now, the other set of amendment was Yashpal Kapoor, who was the gazetted officer who helped Indira Gandhi, about his date of resignation. See, even for that, an amendment was brought, and his date of resignation was put back to a date when Indira Gandhi was not a candidate. So, to wipe out the findings against Indira Gandhi by the Allahabad High Court and the verdict against her, these laws were amended and they were given retrospective effect. Things did not end there. Now, 5th of August is when the amendments to the Representation of People Act and the election laws were passed by both houses of the Parliament, and on the 6th of August, the President gave his assent. On 7th of August, very next day, the Law Minister introduced the 39th Amendment. Now, this is the second constitutional amendment. So, this 39th Amendment was again a watershed moment in the history of our constitutional law, because this attempted to take away the power of judicial review. This virtually placed the election of Indira Gandhi as the Prime Minister beyond judicial scrutiny, and the amendment said that the election of the Prime Minister or the Speaker can be looked at or inquired into only by an authority established under a special law that the Parliament could make, and any election that has been declared void shall no longer be void, shall be deemed never to have been void, notwithstanding any judgment, decree, or order. So there went the order of the Allahabad High Court, and the power of judicial review was sought to be effaced. Now, this amendment was passed in a record time. of about 10 days. 7th August is what I told you about presentation of the bill in the parliament. It was passed on 9th, and on the 9th, 17 states ratified the amendment, and on the 10th of August, the president gave his assent to the amendment also. In the meantime, there is another development, and we should be thankful that this misadventure, which came about on the 9th of August, did not fructify into any law. And the amendment that the law minister proposed on the 9th of August in the parliament was that the president, governors, and the prime minister will have lifelong immunity against criminal prosecution for whatever they did in their lives. Luckily, on the 9th of August, the parliament was adjourned and this bill remained unpassed. So we should thank the stars for that. Nonetheless, please mark the dates. 10th of August is when President gave his assent to the 39th amendment, by which Article 329A was introduced in the Constitution, and the case, Indira Gandhi's election appeal and Raj Narayan's cross appeal, were listed in the Supreme Court on the very next day, 11th of August, before a constitution bench headed by Chief Justice A.N. Ray. Now, on that day, some extraordinary events happened in the precincts of the Supreme Court. And all this is recorded. Being a member of the Supreme Court Bar Association, I have great concern for what happened. It is recorded that only select few were allowed entry into the Chief Justice's court. Only a few lawyers could get inside. Even the press reporters were not allowed. Members of the bar who wanted to go to court and watch proceedings were actually prevented by the police. The Supreme Court Bar Association took serious exception to this, and there was vehement opposition to this. And please mark who was the president of the Supreme Court Bar Association in those days. It was Ashok Sen, who went on to become the law minister in Indira Gandhi's cabinet later on. Now, the Supreme Court Bar Association passed a resolution condemning the act of the court, of the Chief Justice, in preventing lawyers from getting into the court and restricting entry only to a few lawyers. And they decided to boycott the court and pass the resolution that any member defying the resolution of the association and attending court proceedings would be expelled. Now, please look at the result. The result was that no counsel could go to court to represent the parties. In these circumstances, Raj Narayan was kept in Tihar jail in Delhi. So Raj Narayan sent a petition, handwritten petition from the Tihar jail to the Chief Justice, saying that my lawyers are prevented because of this. Permit me to come from jail and represent my case, to appear in person. Nonetheless, 25th of August was when the case was posted, and the Chief Justice relented. He agreed to remove the restrictions, but with a rider. He told Mr. Sen, Ashok Sen, as the president of the Supreme Court Bar Association, that you are responsible for the good behavior of your members. Nonetheless, the case was listed on 25th of August. On 25th of August, the council appeared because the resolution was to be withdrawn by the Supreme Court Bar Association. And by that time, the amendments were in place. So they had to challenge the amendments because the matter now boiled down to, without going into the factual allegations, if the validity of the amendments was decided, if the amendments were held to be bad in law, then only the factual allegations had to be gone into. So the pleadings were accordingly exchanged, the amendments were challenged, and the matter was set down for hearing. Please mark this: in the course of the hearing of the appeal and the cross appeal, the Attorney General, Mr. Niren Day, told the Supreme Court that a review of Keshavananda Bharati is required because the main plank of attack by the petitioners in respect of the amendments, particularly the constitutional amendment, was that it affected the basic structure of the Constitution. Judicial review is part of the basic structure. 39th Amendment and Article 329A took away the power of judicial review, and therefore the 39th Amendment is void. In these circumstances, please note that the Attorney General told the Supreme Court that Keshavananda Bharati, which propounded basic structure doctrine, needs a review. This is as far back as in September 1975. On 9th of October, after conclusion of arguments, judgment was reserved. Judgment was delivered by the Constitution Bench on 7th November 1975. I forgot to tell you this, and this is extremely important. Please mark this. In the course of the hearing, the bench consisted of Chief Justice Ray, Justice Matthew, Justice Khanna, and Justice Beg. The bench told Mr. Shanti Bhushan that they were considering only the amendment, the validity of the amendments of the election laws and the constitutional amendments. And therefore, since they were not going into the factual allegations of corrupt practices or the factual findings rendered by the High Court, he need not argue on the factual aspects. So accordingly, counsel had molded their arguments in that fashion. On 7th of November, judgment was delivered. The court was unanimous. The findings were twofold. 39th Amendment, by which Article 329A was introduced in the Constitution, was struck down, holding that it took away the power of judicial review, which is part of basic structure. So therefore, the amending power of the Parliament is not unlimited. And in the light of Keshavananda Bharati, 39th Amendment was declared void. But the other set of amendments, which had been given a retrospective effect, relating to the Representation of People Act, by which the definition of corrupt practices and the electoral laws amendment, those were held to be valid, and the retrospective operation of those laws was also held to be valid. And the reasoning was very simple, that it is the plenary power of the legislature to legislate on a subject which is within its legislative competence under the Constitution, list 1, list 2, list 3. If it is within the legislative competence of that particular legislature, the plenary power extends to determining from what date the law should take effect. Justice Khanna, in his separate opinion, has recorded that in a particular case, when laws like this relating to election are given a retrospective effect, it may cause prejudice to a certain party. But he says that does not matter, because that is not a ground to strike down the law itself. And if any action is taken under that law, such action should be struck down, but not the law itself. So since the corrupt practices were no longer on the statute book because of the retrospective operation, naturally the judgment of the Allahabad High Court was set aside and the election appeal was allowed. Indira Gandhi's election appeal was allowed. But a very strange thing happened, and this is Justice Khanna has recorded this with a great sense of regret in his memoirs. Justice M.H. Beg, who was also on the bench, while the other four judges confined themselves true to their word given to Shanti Bhushan, that they would hear and pronounce only on the validity of the amendments. Justice Beg proceeded to consider the factual allegations and pronounce on the corrupt practices and the findings given by the Allahabad High Court. Now, when this judgment came, Shanti Bhushan found that unacceptable because he had not argued, he had no chance to counter what the judge has found. So he filed a review petition. When he filed a review petition, it was taken up in open court. Justice Beg was furious and strictures were passed against Shanti Bhushan and all kinds of things were said, saying as a counsel appearing in the Supreme Court, you should know what could be put against you. All this is in the course of the order, if you read the order of Justice Beg. And the review petition was dismissed. Like I said, Justice Khanna has recorded in his memoirs, Neither Roses Nor Thorns. He says on that day, when the review petition was dismissed and the judges rose and they were going out of the court, his colleagues whispered in his ears that it was indeed a black day in the history of the court. Now, please bear this in mind. It was that very Justice M.H. Beg who was appointed as the Chief Justice of India by superseding Justice H.R. Khanna for his judgment in the Habeas Corpus case. We will come to that a little later. Now, this was about the judgment in Indira Gandhi's election appeal. I told you the date. It was 7th of November. 3 days later, on the 10th of November, Chief Justice A.N. Ray constitutes a bench of 13 judges in an attempt to review Keshavananda Bharati. Now, it was obvious no party had asked for a review of Keshavananda Bharati, but the bench was constituted. Palkhiwala was the lead counsel opposing the attempt to review. And he was vehement in his opposition. And permit me to quote from the propositions that he had given to the court. He says, this honorable court would be stultifying itself and would cause grave misgivings in the public mind about the stability and the continuity of the law. And this was said because 3 days ago, in Indira Gandhi's appeal, the 39th Amendment was struck down, relying on the basic structure doctrine of Keshavananda Bharati. Now, on the 10th of November, you want to review the basic structure doctrine of Keshavananda Bharati. So he said this, and the judges, in fact, this is also recorded. The judges had no clue. There were whispers amongst the judges of the Supreme Court that there is a possibility of the Chief Justice constituting a bench to reconsider Keshavananda Bharati. And Justice Khanna goes to the extent of saying, and this is really, really concerning, he says, as judges of the Supreme Court, they were living in an atmosphere of gloom and fear. And they were afraid that in that atmosphere of fear, Keshavananda Bharati could be reviewed. So with that mindset, they were on the bench. When Palkhiwala argued, and Justice Khanna records that the heights of eloquence to which Palkhiwala rose that day were rarely equaled and seldom surpassed in the history of the Supreme Court. Lo and behold, on 13th of November, in the morning when the bench assembled, the Chief Justice announced that the bench was dissolved. So we should again be thankful to our stars that the country was saved of Another unfortunate event. Now, although the attempt to review Keshavananda Bharati was averted, successfully averted, darker days were ahead for us. And I'm saying this not from any political point of view or from the point of view of a layman. As lawyers and judges, we have certain responsibilities, and the Constitution is our guiding light. In 1976, the high courts in the country, across the country, they were refusing to entertain writ petitions asking for habeas corpus when somebody, a citizen, is illegally arrested or detained. Most of the high courts were toeing the line of the government on the pretext that the fundamental rights had been suspended because of the emergency under Article 359, and therefore the protection of Article 20 was no longer available. 20 or 22 were no longer available. Only 9 high courts stood up to the occasion, and one of them was the Madhya Pradesh High Court. In fact, of course, I am from Karnataka, and right now sitting in Karnataka, Justice Sadanand Swamy of Karnataka High Court had also taken a view, and he was transferred. We'll come to that, the meddling with the judiciary. The lead case that reached the Supreme Court was ADM Jabalpur versus Shivkant Shukla. Now that arose from Madhya Pradesh High Court. The judge who decided that case in the Madhya Pradesh High Court was Justice Anand Prakash Sen, AP Sen. Justice AP Sen held that no matter the fundamental rights are suspended and the emergency is in operation, you cannot deny the protection of law of life and liberty to a citizen. That judgment was carried in appeal, and that was the lead matter. Justice AP Sen was transferred from Madhya Pradesh High Court to Rajasthan High Court for his judgment against the government. And later on, he was appointed Chief Justice of the Rajasthan High Court. By that time, the election had happened and the government had changed. Janata Party had come to power. Justice AP Sen's nephew is a very dear friend of mine, and I spoke to him yesterday and collected this information personally from him. The Janata government told Justice AP Sen that we will elevate you to Supreme Court from the position of Chief Justice of Rajasthan High Court. I believe he refused. He said, a great wrong has been done to the judiciary by transferring me for my bold and fearless judgment. Take me back to my home High Court. So he was taken back to Madhya Pradesh High Court as Chief Justice. And in 1978, from there he was brought to the Supreme Court. From 1978 to 1988, he was holding the position of the Supreme Court judge. And believe me, a judge who holds the position of a Supreme Court judge for about 10 years would surely have become the Chief Justice of India. But in that time that elapsed, where he was repatriated from Rajasthan to Madhya Pradesh and then brought to Supreme Court, Justice R.S. Pathak had been appointed, and Justice AP Sen lost out on being the Chief Justice of India. Not that it mattered to him. We knew him personally. He was one of the most upright judges that the country has ever seen. He was a bachelor. And on the day he demitted office, he had packed his suitcase. He vacated his official bungalow, refused a farewell from the Supreme Court Bar Association. From court, he went to the railway station and went back to Nagpur. So that is the kind of the mettle of judges that we had. That was one instance of meddling with the judiciary. There are 2 other instances which are recorded by the Shah Commission. And these 2, please mind, these two judges were tampered with because of their fearlessness. The first is the case of Justice R.N. Agarwal of Delhi High Court. He was a serving district and sessions judge who was appointed as an additional judge of the Delhi High Court. Because he entertained a bail application or gave some relief to a détenu, he was reverted from the position of an additional judge of the High Court, a constitutional position. He was reverted as a district and sessions judge. And later on, when the government changed, he was again appointed as a permanent judge of the Delhi High Court. Second instance is of Justice Umesh Ranganath Lalit, Chief Justice Uday Lalit's father. Uday Umesh Lalit's father. Chief Justice Umesh Ranganath Lalit was an additional judge of the Bombay High Court, and he entertained the plea by a détenu. His continuance as a judge was refused by the Prime Minister. These are documented, and there is a note where the Prime Minister of the day wrote on the file that I do not want him to continue as a judge, and she underlined the word not. These two cases of Justice R.N. Agarwal and Justice Umesh Ranganath Lalit have been recorded in the findings of the Shah Commission, which went into the excesses committed during the emergency. In the first interim report submitted by the Shah Commission, findings have been recorded that on account of the non-continuance of these two honorable judges, there was abuse of power by the then Prime Minister. So that was the kind of meddling or tampering with the judiciary that happened in those days. Now is the time to consider why we are having the collegium system today. Now, if this was the kind of meddling by the executive with judiciary and judicial appointments, ultimately it paved the path to a system where the judiciary had to be insulated. And this is a theory which is propounded by Tempton Andhyarjuna in an article written by him in 2017. And he makes a direct link between the attacks on the judiciary during the emergency and the evolution of the collegium system. And it makes perfect sense. So today here we are in a somewhat insulation of the judiciary from the executive. Now, then we come back to the judgment in the habeas corpus case, ADM Jabalpur versus Shivkant Shukla. The majority did not stand up to the occasion. They toed the line of the government and held that citizen has no remedy before a court of law when the fundamental rights are suspended. And the lone dissent was that of Justice H.R. Khanna. Justice Khanna knew that his dissenting judgment would cost him Chief Justiceship of India. In fact, just before the judgment was pronounced, he was in Haridwar, and he told his sister that I have prepared a judgment which is going to cost me Chief Justiceship of India. So therefore, the price that we had to pay was lose the most upright and one of the finest judges that the country ever had. Justice Khanna resigned from his post on 28th of January 1977, and immediately his junior, Justice M.H. Beg, was appointed as the Chief Justice of India. Now, when this happened, one would be wondering that Palkhiwala, who was the most vocal champions of civil liberties in the country, fundamental rights and civil liberties, why is it that he did not appear in the habeas corpus case? And in a letter addressed to one of the senior advocates who's now practicing in Supreme Court, and that letter is in public domain, Palkhiwala has clarified that he was asked to appear in the habeas corpus case on behalf of the petitioners. He refused because he says that the judges of the Supreme Court in the dark days of emergency lacked moral courage. These are not my words. I am quoting Palkhiwala. He said exactly this. And he has also recorded that Justice Chandrachud, who was one of the parties to that judgment in habeas corpus, the majority opinion, later on regretted that his judgment was wrong. And please also bear this in mind. In 2016, in K.S. Puttaswamy, Chandrachud Jr. overruled Chandrachud Sr. So one had to wait for more than 4 decades for that to happen. So on the resignation of Justice Khanna in March 1977, the elections were announced and the emergency was revoked. One more interesting aspect. Why was the emergency revoked? There are several theories, but that's a political aspect, but something interesting. It happened. You know where it happened? Those were days of the Kumbh at Prayagraj. Indira Gandhi went to Prayagraj to take a holy dip on the day of Amavasya, supposed to be the holiest day of the season. And while at Prayagraj, she made the announcement that things are under control now, so we are revoking the emergency and elections will be held. So the declaration from the Prime Minister came in Prayagraj. And in 1977, 21st March 1977 is when the proclamation of emergency was revoked and elections were held. So, as we all know, Indira Gandhi was defeated, the Janata Party came to power, and Morarji Desai was installed as the Prime Minister of the country. Shortly after he was installed as the Prime Minister, Morarji Desai invited Justice Khanna for a meeting. And please see the level of moral rectitude that public figures and public authorities had in those days, both the executive and the judiciary. Please look at this. The purpose of the meeting was the Prime Minister tells Justice Khanna that the government now wants to ask the incumbent Chief Justice of India to resign, to step down. And we want to appoint you, Justice Khanna, as the Chief Justice of India. Justice Khanna said nothing of the kind will happen. Look at the rectitude, the integrity and the character of the people, character of the judges and the executive that we had in those days. Anyway, so when that was refused by Justice Khanna, the Prime Minister made a request that please prepare a note suggesting some constitutional amendments. And please mark these words. Why did he ask for it? He said, so that the horrible things that happened during the emergency are not repeated again. Justice Khanna readily agreed to that and he prepared a note. That note was accepted by the cabinet, and in the 44th amendment that was passed in 1978 of 1977, it became an act in 1978. All the suggestions given by Justice Khanna as to the safeguards and guidelines for issue of a proclamation of emergency, the express exclusion of Articles 20 and 21 from the suspension of fundamental rights under Article 359, all these were accepted by the government. Then, of course, we've come to the 44th Amendment. One thing that I have to mention is a very brief mention of the 42nd Amendment. That assumes a little importance because although the other judges in the Minerva Mills case, which was decided in 1980, they do not discuss this aspect of emergency or 352, whatever. Justice Bhagavati, in his partly dissenting and partly concurring opinion, he refers to Article 352 and he gives a very significant finding, which is that judicial review is part of basic structure. So notwithstanding 352(5), which was introduced by the 38th Amendment, the power of judicial review cannot be taken away. A proclamation of emergency is justiciable and the court can look into the existence of circumstances warranting a proclamation. So that brings us to a bird's eye view of what all happened to the constitution, to the legal system, to the court, and to the citizenry during the emergency. Like I said at the beginning of my talk, I had written on 50 years of emergency in a Kannada daily, and I had various responses, very, very valuable inputs from eminent personalities. One response that I received was from a former Chief Justice of India, and I respect his point of view, although I may not agree completely with whatever he said. His first response was that with the amendment, 44th Amendment and the express exclusion of Articles 20 and 21 from Article 359, this whole debate has become academic. Now, I don't agree with that because unless we as citizens and responsible citizens and as lawyers are not vigilant, we do not remind ourselves of the excesses, constitutional excesses that were committed, we will never be able to avert such a crisis in the days to come. But the other input that the respected Chief Justice gave me is very valuable. Please appreciate this. What he said is this. He said, however harsh a law may be, the judiciary should be strong enough to implement the law in such a way as to be in conformity with civil liberties. So the answer boils down to a strong and robust judiciary. I had another feedback from a very dear friend, a classmate of mine who's a professor of law. So that academic point of view also came in. And his response was, he said, we the people is the answer. Now I really liked it. Come to think of it, experience shows that it was after the passing of the 44th Amendment when people's mandate changed the party in power and the new government passed the 44th Amendment and the earlier wrongs were set at naught. We had no hope. So therefore, it's actually the power lies in we the people. So long as the citizenry is vigilant and we as lawyers play our roles responsibly, there is hope for this great country. Thank you, ladies and gentlemen.
Thank you. So elucidatedly explained. I'll ask Mr. Surendran Rao, who has also done various sessions with us. He was right and throughout the session with us to share his thoughts. Yes, sir. No, he's not unmuting himself. Okay. Yeah. Raghvendra?
Please unmute Mr. Rao. You wanted him to speak.
Mr. Rao is not. Mr. Rao? Yeah. I'll ask Prashant.
Thank you, Raghvendra and Vikas Chatranth. I think Raghvendra had not been even born at that time,
I
1970.
was born during the emergency. Therefore,
Oh, I didn't know that. Okay. But we were all born and we had known little about it. But it was very nicely put. Every event was nicely explained, structured well. I already put my comment in the comment box. I would only say we should have known it very well before. We know about emergency and the period thereafter, but not so meticulously as he has put it. Good effort. All the best, both to the organizer as also the speaker.
Thank you, everyone. Stay safe, stay blessed. Namaskar.